Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on the Prevention of Corruption Act. The justice says that the prosecution must prove the case beyond all reasonable doubt. If there is any iota of doubt, the benefit will go to the accused. This is what is stated by Justice Jasmeet Singh of Delhi High Court in a corruption case against a sub-inspector of police. So this relates to criminal appeal number 618 by 2000 decided on 1/9/2023 under the caption Delhi High Court set aside the conviction of police official in a bribery case. Normally, in bribery cases, no mercy will be shown even to the police also. Normally we have been seeing in so many cases, if a case is booked under section 7 or 12 or 13 of the Prevention of Corruption Act 1988, because of the phenolphthalein test, because the the fingers will turn pink color. So that itself is a very good corroborative evidence and he will be convicted. But the conviction, to give conviction, there should be proof. That proof should be beyond all reasonable doubt. If it is not there, definitely this person will get acquitted. That is what happened in this particular case. Now let us know the details of the case. Here, a woman complainant. She is a woman complainant. So she went to the PS in the year 1991 and filed a complaint against her neighbor. She wanted to take action against her neighbor because of the quarrels. Right? So the SHO, because in Delhi the SHO is the DSP, the officer in charge is the DSP, he has entrusted the matter to the particular sub-inspector of police against whom we are all now the case has been acquitted. Right. So she approached him. So she wanted the arrest of the neighbor. She tried to manage him and allegedly this man said, if you want to arrest him, you have to pay me some 2,000 rupees. Exactly how much? Not arresting neighbor. Okay. Only 2,000 rupees. Actually, nowadays 2,000 rupees is very simple amount. So maybe 1991, it may be a great amount. So he amended 2,000 rupees. She said she could not give that much and he agreed to get it in installments, 2 installments. So at the time of the so-called first installment, actually she informed the ACB, she went there, she gave the money and immediately after his receipt, his hands were put in the so-called sodium carbonate solution because already the currency notes, they were tipped with phenolphthalein powder and his hand or the fingers of his hand turned pink color. Finished. So he was booked under section 17 and 13(1)(d) of the Prevention of Corruption Act. So the trial court convicted him, 1 year. Convicted him for 1 year and also imposed a fine of rupees 500. Right? So this is the case. Now this man has come in appeal. So he has, in this case, the advocate for him, he has argued that he was implicated falsely in this case. Only one point. The neighbor whom the complainant lady wants to arrest, already he has approached the court and got bail. When he got bail, how can this SI arrest the neighbor? Is it possible? No. Second, except the evidence of the complainant, the others, the so-called the other independent witnesses or other ocular witnesses, all of them turned hostile. When the police officer knows that already the accused surrendered to the court and got bail, there is no reason in demanding bribe. Fact is, some people will be there. Even to call him to the police station, they demand money. Right. Now here, the court held that the evidence of the complainant is not untrustworthy. It is not trustworthy. And the independent witnesses did not support the case of the prosecution. Ultimately, the court will point that she has got the ulterior motive to get him arrested. And of course, the solution turning pink color, it has no bearing by settled law principles. Of course, it's only a corroborative piece of evidence. All of us know this. So that's why, if at all the evidence is there, it should be corroborative. The evidence should be concrete and the motive should be clearly established. Otherwise, even the police officer also can get an easy chance of acquittal. So read the judgment and enrich your legal knowledge. This is the Delhi High Court judgment, criminal appeal number 618 by 2000. Thank you.